Hi everyone, it's Tim McCormack and I'm really pleased to welcome you to this fifth question and answer session in LawFest 2020, this time on the subject of social media and employment law. Before I introduce Lucy and before I make a few household or housekeeping announcements, let me take this opportunity to acknowledge the traditional owners and custodians of the land on which we're each gathering. In my case, the Blair Hekahelaplu people of the Burnie region on the northwest coast of Tasmania. In Lucy's case, the Wurundjeri people of the Kulin Nation, because Lucy's in Melbourne. And for the rest of you, wherever you are in Tassie, your traditional owners in the part of the state you're in, we know that as a consequence of violent dispossession, there are no longer descendants of each of the tribes around the state, and instead, and fortuitously for us here in Lutruwita, Tasmania, we have a remnant of Aboriginal people that survived on the northeast islands in Bass Strait, and from them are descended our contemporary Tasmanian Aboriginal community. I pay my respects to their elders, past, present and emerging, and express profound admiration and gratitude to them for the way in which they have nurtured their cultural, linguistic and legal traditions despite all the adversity thrown at them. Before I introduce Lucy, just a few housekeeping things. One thing to say is that the recording function and hand raising functions have been disabled so we can protect your privacy. If you've got any questions for Lucy or for myself as we deal with the questions we've already received, then don't hesitate to send them through on the Q&A function at the bottom of the toolbar on your Zoom screen. I should also just say thanks to all of you who've prepared questions for us and sent them through to us through your legal studies teacher. It's been really great to receive questions, and I hope that you've enjoyed, as I have done, watching the pre-recorded presentations that Lucy and Mark have both made. If you've got any questions more generally about the study of law or anything else, then please join me and Dr. Matt Killingsworth at 3:30. We're just going to have an open Q&A session across whatever topic you might want to raise with either of us. Lucy, it's really lovely to have you join us this afternoon. Thanks very much for doing that. As I mentioned before to people who are watching, Lucy's in Victoria. She's a barrister at the Victorian Bar of the Supreme Court, but also an adjunct lecturer with us in the law school at UTAS. We're very proud to own her as one of our most illustrious alumna. Lucy graduated in BA and LLB, first class honours in law, and she was a university medalist when she graduated. You don't get that unless you're really exceptional. And fortunately for us, even though Lucy's made her life in Melbourne, she's really happy to maintain an ongoing relationship with the law school in Hobart, and she and Mark regularly teach employment law for us in our LLB program. So thanks very much for joining us, Lucy, and yeah, thanks again for the great presentation that you've made and that students have watched. As you know, we've got a few questions that have come out of that. So let me combine one from Claremont College up in the upper reaches of the Derwent, not very far from Mona, in fact, with a second one from Guildford Young College in the Glenorchy campus. So they're probably two schools in the state that are most physically proximate to each other, only a few kilometres apart. Perhaps Don College and St Brendan Shore and Devonport take the cake. I don't know, but anyway, it doesn't matter. So from Claremont, one of the students asked, have there been any government or other inquiries into social media use in employment law? And is this an area of law that needs reform or clarification and reform? And let's combine that with a question from the Glenorchy campus of Guildford Young. Guildford Young also has a campus in West Hobart, but this is from one of the students at Glenorchy. Are there any plans for specific law covering social media use in the workplace? And especially, the students said, especially because unfair dismissal falls under the Fair Work Act, are there any plans for a sort of separate and distinct social media use in the workplace type legal regime. Thanks.
Thank you very much for that generous introduction, Tim, and it's a pleasure to be involved and get such great questions. So I'll start off answering that compound question. Mark Rinaldi also sends his regards. He couldn't be here, but Mark and I have discussed these questions, and we agree that to our knowledge there are no inquiries into social media use and employment law, and they haven't been until this point, but certainly in 2017, the Silk Jeremy Kirk, when making submissions to the High Court in the case of Gaynor and Chief of the Defence Force number 3, made the comment that there are some interesting issues just over the horizon relating to social media and members of the public service. So it may be that at least in terms of the bench and the judiciary, that we'll see some more consideration about social media use, particularly in the public service. As far as Mark and I are aware, we're not aware of any law reform that's been proposed in this area or plans for separate social media law. This is the Fair Work legislation, and you can see how thick it is. So this is already extremely highly regulated and technical area. And I think that the general feeling is that the use of social media in employment law can already be encapsulated within the legislative provisions that we already have. For example, bullying, cyberbullying, that can already be accommodated under the legislative provisions in the Fair Work Act that deal with bullying generally.
That's if the bullying happens in the workplace, of course.
Yes, well, that's right.
Cyberbullying isn't limited to that. I was thinking before we started the session, Lucy, that how novel this sort of concept is. I mean, it wouldn't have even been 10 years ago, maybe less, that we wouldn't have even contemplated having a session at LawFest on social media use and employment law. It's a really rapidly evolving area of contestation of different competing interests, isn't it?
Oh, it is. And it's just changed the entire way that we do work. I was thinking about when I went through university at UTAS, email existed, but it just really wasn't a cultural thing that students would email staff very often. Whereas now, frequently students email staff, and it's facilitated a lot more communication more regularly. So I think that technology certainly is driving cultural change within workplaces, and the law will have to deal with that.
Yeah. So you were mentioning the Gaynor and Chief of the Defence Force, Jim Gaynor's the Inspector General of the ADF. In terms of, the judge making observations in that particular case about this, it's not far over the horizon, we're going to have to deal with this more and more. And the second question, also from Claremont College, is about Commonwealth Department of Industry's direction to one of their employees, a guy called Josh Crook. I didn't know this case myself, but I'm interested in it, who was directed to remove a blog post or face termination. And the student asked the question, given that apparently, I haven't read the blog post myself, but the question seems to imply that the blog post is not critical of the government or of government policy. So what's your reactions to that particular situation?
This was a great question because I wasn't previously aware of this either. So I went and read the media article, and then I found the blog post, which is still published on the internet, and went and read that. And what was really fascinating is the difference between how something was reported in the media and how, when you went to the original source and looked at the blog post, at least to my mind, things look quite different. So you're quite right. In the media article, it said that it wasn't critical of the government, and it was general, and it was apolitical, or at least that was the view of the author. I went and read the original blog post. Keep in mind that this was someone who worked at the Department of Industry in the federal government in technology policy. And I'll just read a few paragraphs from the blog post so that you can have a flavour of what this employee, while he was employed, was saying. He was talking about COVID and big technology, and how, in his view, big technology was benefiting from the emergency situation we found ourselves in. And he was saying things like, in the blog post, "If this is the utopia Silicon Valley dreamed of, it is the worst utopia of all time. Replacing human connection with technology has never felt so nakedly negative. Everywhere, people are realizing that the tools and apps that we rely on are not enough. We crave real connection. We crave reality. The tech companies may have our attention, but at least for now, they do not have our souls. Modern tech companies have long desired for us to be tuned into their systems 24/7, and as a result, disconnected from everything else around us, the outside world, external experiences, and authentic human connection." So that's very emotive and inflammatory language against tech companies. And on one view, the Department of Industry, and certainly someone who's involved in tech policy in the Department of Industry, may suffer consequences in trying to liaise with stakeholders in the private sphere if their employees are writing these kinds of things. So it's a question of the Australian Public Service employees have to be apolitical. It's a question of how broad is that? Is it so narrow as to just be references explicitly to existing law, existing policies? Or does it include these kinds of comments that are quite inflammatory, quite emotive, and understandably would be alarming for the government to read that their employees are writing, in effect, that tech companies are divisive and contrary to the welfare of society? So I think this question was a good lesson in terms of look behind the media, look right back to the source, and then see what the true situation is. Another thing that I picked up from this question is that in the media, it was reported that this person was on a non-renewable contract and the contract wasn't renewed. When you go to the blog post, the author of the blog says that he resigned from his position. And you see that all the time when you're practicing law, that there are different accounts of what actually happened. And as a lawyer, it's part of your job to get down to the bottom of things and work out what's the real situation.
Oh, that's great. Thanks for the answer. As an academic and a teacher, I feel slightly aggrieved about the fact that we've had to go into emergency online delivery, because I really miss the interaction face-to-face with my students.
Yeah.
And somehow or other looking at a wall of names, because it seems like a majority of students who are joining a synchronous tutorial session, for example, are choosing not to turn their video on, and only a handful of them are. I'm instantly drawn to the faces I can actually see on the screen rather than the blank ones, thinking, yeah, this is not working, this is not how it should be. So I could imagine tweeting or, using some other social media platform to say, I don't like this. This is not what we signed up for. I mean, it's better than not having any ongoing classes at all, but it's suboptimal in terms of the mode of delivery. But I guess it'd be, and the university might not like me saying that as an employee, that I would much prefer face-to-face delivery of content. But I guess it's a different situation when this person's working in technology and Department of Industry and saying it about some of the very stakeholders the department's trying to engage with.
Yeah.
Interesting issues. Lucy, as you know, there's a couple of questions from Helly College. If I look out the window off to my left, out the Cradle Coast campus, I can see the campus of Helly College, and a couple of students up there, or I don't know whether a couple or one, interested in the case of Israel Folau. And the first question about the Izzy Folau case is whether or not you agree with him. I mean, I've got my own views about his views, but whether you agree with those views or not, isn't he entitled to express them publicly? And should Rugby Australia have been able to terminate his contract just because he was expressing his personal views?
Again, that's another fantastic and very topical question. Mr. Folau played rugby for Rugby Australia, and he posted online various comments on social media about his views, which many people regarded as homophobic. And this resulted in people complaining to Rugby Australia, his employer. He posted comments in 2018. He was pulled up on that by Rugby Australia and promised to curtail his comments. But then in April 2019, posted a picture on Instagram that read, "Warning, drunks, homosexuals, adulterers, liars, fornicators, thieves, atheists, idolaters. Hell awaits you, repent, only Jesus saves," which was accompanied by a Bible passage. And Mr. Folau was dismissed by Rugby Australia for posting this, and he brought a matter in the Fair Work Commission claiming unfair dismissal, and he was claiming it based on religious discrimination. And under the Fair Work legislation, the religious discrimination of the employees by employers is unlawful and is contrary to that act, and dismissing people for that reason is not a lawful reason to dismiss. So he brought this matter to the Commission, and as they often do, the matter wasn't settled there and went to the Federal Circuit Court. Whether or not you agree with his views, should he be entitled to express them publicly? People have differing views about that. Professor Singer, Peter Singer, has commented that in effect, suppression of these kinds of views is contrary to an open society, open discussion in society, and that we shouldn't be asked as employees to suppress our views in public just because some people might find them offensive. And it amounts to restricting our freedom of speech. Of course, if you study law, then you study the Australian Constitution and constitutional law, and under the Constitution we have an implied freedom of political communication. So that's something else to keep in mind, that not only are our rights protected in the employment sphere by the legislation, but also by the Australian Constitution. What was interesting about the Folau case is that ultimately he had signed a code of conduct agreeing to comply with that code of conduct. And what his employer was arguing was that he had breached his employment agreement by breaching that code of conduct. And that code of conduct prohibited rugby players from engaging in discrimination and publicly making comments or using social media in a way that does not treat people fairly and with dignity. So when, as an employee, you go and sign something like that, then it's a whole different avenue in terms of what your ability is to voice your views in public. And perhaps if he had not signed that code of conduct, things would look quite different in that case. So that's just another avenue of how the landscape can change depending on the structure of the contractual arrangement between employee and employer.
Yeah, I mean, that's great. Thanks very much for the answer. I got my own views, of course, it's quite strongly held about Israel Folau's views, but I accept that he's entitled to them. But it's interesting to know about the code of conduct that he signed up for and got paid a fortune to play rugby very, very well indeed. So there's a follow-up question about the Israel Folau case also from Helier College, and that is that if Rugby Australia believed they had the right to terminate his contract, obviously they did because that's how they acted, why did they end up settling out of court? That's sort of an admission that maybe the case wasn't watertight, or that question doesn't ask that. I'm adding that. What's your own views about that, Lucy?
We can only speculate, Tim, but as someone who's practiced law for some years, I know that often cases settle for reasons other than the black letter law and the merits as between the parties. I can give you an insight into a number of reasons why cases might settle out of court. One obvious one is that litigation is very expensive. And this matter was a complex matter. The amended statement of claim ran to 40 pages. It involved two respondents, Rugby Australia and the Waratahs Rugby Proprietary Limited. It concerned novel areas of law where it was unclear what the court would decide if the court did have to reach judgment. And so there was also an element of risk running the matter to a contested hearing. Also, litigation takes a long time. It may have taken several months, if not years, to resolve this matter, particularly because it was such a high-profile matter. What one might have expected to see is that if it ran to judgment in the Federal Circuit Court, it may well have been appealed to the Federal Court and perhaps even to the High Court, given the importance and novel nature of the matters in question.
Thanks, Lucy. And presumably there was just as there was some uncertainty for Rugby Australia about those sorts, Rugby Australia and the Waratahs. I didn't know the Waratahs were joined as second party, but just as there were uncertainty for them, there also must have been uncertainty for Israel Folau and his lawyers themselves, and no guarantee that they'd win. So some incentive to reach some sort of agreement, presumably involving substantial amount of money.
Yes. Well, that's absolutely right. I mean, whoever you are, when you're involved in litigation, there's always an element of risk. You might feel that your case is really strong, but you never know what a judge or the panel of judges might think. And reasonable minds differ all the time. And so there is always a great element of risk in running a matter to a contested hearing, even if you consider that you're in the right. Also, with the settlements are confidential. Perhaps he got a large payout and perhaps it was a modest payout. We'll never know. And that's one of the benefits, I suppose, of settling matters out of court. It allows the parties to tailor their final resolution according to their interests rather than leaving it up to chance and what judges think.
Yeah, great. Thanks, Lucy. Perhaps a question from me as we get close to needing to wind up the session. What do you have any thoughts about where the sort of future might lie in relation to increasing technological capability, the use of social media, and circumstances in which employers might want to place limits on or curtail the use of social media platforms by their employees?
Yeah, I think it's we're in a brave new world. I think a lot changed back when Blackberries were popular, and suddenly employers were being issued Blackberries by their employers, and with the expectation that accompanied that employees would possess these mobile phones and be on these smartphones at whatever time. And I think that in retrospect was a fundamental change in culture that people didn't really appreciate at the time. Perhaps students here don't know what Blackberries are because no one uses them anymore, but they were the original smartphones. And now, of course, everyone carries smartphones, and increasingly people are online 24/7, are constantly checking their emails, and there's a real blend between private life and work life, and particularly I've seen since COVID, where people are working from home, that blend has just gotten even more enmeshed. So it's very unclear now where private life ends and work life starts. When always on your mobile phone, you're flicking between personal messages, personal emails, personal phone calls, and work. And so I think we'll see that in terms of the law. We'll probably see employers continue to try to monitor their employees and try to monitor what they do on social media platforms. And perhaps we'll at the same time see some resistance and pushback to that as well from employees. So it'll be interesting to watch. Yeah,
thanks for reminding me about Blackberries. I'm old enough, as you know, to be very well aware of the advent of that new technology. And, you know, it would have been hard to anyone to be bold enough to say that this phenomenon, which they were, I mean, they were just, so many people had them that 10 years from now, there'll be no one will even know what you're talking about when you use the term blackberry, other than a berry that's growing on a bush.
Yeah, exactly.
Wild in Tasmania that you can pick if it hasn't been sprayed with poison. Don't you think that, that just says so much about how rapidly the technology changes, doesn't it? That I don't even know whether BlackBerry still make a smartphone, but they've certainly been completely overtaken by Apple and by all the other, Samsung and Google even, and with all their mobile phones. They're smartphones, I mean, not just mobile phones, but they're smartphones. Nokia is trying to have a bit of a resurgence. There was a time when you were a young girl, Lucy, where Nokia were ubiquitous, like the Apple iPhone.